Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Hello? Hello? Morning.
Good morning, Your Honor. How are you doing?
I'm not bad, counsel. How about yourself?
Good, yo, living the dream.
I hear you. What file are you here on today?
You're for Michigan First Credit Union. My defendant is Jennifer Sneed Jackson.
I think I have her here. Let's get her. So let's see if we can't get started.
Perfect.
Having trouble connecting her to audio, apparently.
Yep.
Let's try it again. Hello.
Hello.
Turn your video on, please. This is file number 14112-208. Michigan First Credit Union versus Jennifer Sneed. Date and time for objection to garnishment. Your appearances.
Your Honor, Michael T. Merritt, P81102 on behalf of plaintiff.
What is your name, ma'am?
Jennifer Sneed Jackson.
You are the moving party. What is the basis of your objection to garnishment?
My objection to garnishment is I shouldn't owe them anything. My car was repossessed back in 2008 for non-insurance. I called them several times. I was told that I couldn't get my vehicle back, whether I got insurance or not. After that, maybe 3 or 4 months later, they called telling me that I owed them this money that I can come and pick up my vehicle. By that time, I already moved out of town, purchased another vehicle. I just had paid my car note 14 days before my car was repossessed. I was in the process of getting insurance. I purchased insurance and they told me that it was too late. Then 5-6 months later, they tell me I can come and pick up my vehicle.
Okay. Is there anything else you want to tell the court?
No, not really. I've been dealing with this situation for 14 years.
Oh, ma'am, that's not factually accurate.
I mean, for a long time. I'm sorry. A long time. Since 2008.
Counsel, your appearance.
Your Honor, Michael T. Merritt, P81102.
I'm sorry, you told me. I'll take your response. Excuse me.
Oh, no worries. No worries. Your Honor, the defendant's attempting to attack the underlying judgment, which is explicitly prohibited under the court rules. I believe it's MCR 3.101. However, getting to the heart of her actual argument, judgment was taken in 2014. This is the first time the defendants raised these issues. At one point, I believe, or on two separate occasions, I believe she motioned the court for installment payments as well, admitting to the debt. So, I mean, not only has she already admitted to and attempted to make payments on the debt, but again, her entire argument is explicitly prohibited under the court rules.
Anything else you want to tell me, ma'am?
Say that again. What did he say?
Is there anything else you want to say in response to what he said?
In response to what he said, when I got the original judgment, it was through Michigan First Credit Union, who I had a bank account with. In 2014, when I put the form in to make payment arrangements on it, as far as I knew, it was to that bank for my for my bank account. I wasn't aware that it was for this vehicle for the 2008 Aspen until 2017.
Okay. The court's prepared to rule in this matter. The file indicates that defendant was personally served with summons and complaint on July 18, 2014. She failed to respond, and more than 30 days later, August 25th, 2014, judgment by default was entered. The record further reflects that on November 12th, 2014, the defendant sought to have a installment payment. The court denied that order. Installment payment was ultimately granted in December of 2014. That was then set aside. In any event, Michigan Court Rule 3.101K is quite specific. The defendant may not use the objection to garnishment as a method of challenging the validity of the underlying judgment. Having failed to state a valid objection to garnishment, the objection to garnishment is going to be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to you both an order. Thank you both for coming in. We are off the record.
Thank you, Your Honor, and have a great day.
You too, sir. Hello?
Yeah. Hello?
What is your name?
Lakeisha Berry.
Hold on for a moment.
No problem.
Get you started.
Okay.
For Auto Club. Counsel, good morning.
Good morning, Your Honor.
We are on the record calling 2-1-163-739. Auto Club Group versus Lakeisha Berry. Date and time for objection to garnishment. Your appearances.
Dylan White, P80755 for Auto Club Group.
And what is your name, ma'am? Hello?
Lakeisha Berry.
You are
Lakeisha Berry.
What is the basis, ma'am, of your objection to garnishment?
Say that again?
You are the moving party here. What is the basis of your objection to garnishment?
They said they served me, but I never received any papers being served for me being garnished. And then when I called to see if I can get a financial statement so I can pay a low amount because I'm going through financial hardship right now, they denied me and told me I had to pay $1,200 down, $400 a month. I can't afford to pay that at all.
All right, ma'am, do you have any? Wait, I'm sorry, I didn't mean to cut you off. What else did you want to tell?
Oh, no, I'm sorry. Oh, I can't afford that. I'm a single parent. I don't have that type of money.
Okay. Anything else you want to tell me?
If they're able to work with me and accept the payment that I originally sent in, as far as like my check stub, I can make that payment, but I can't afford no $400 a month,
All
and my rent by itself is $1,100. I can't afford it,
All right,
and I have children.
counsel, your response.
Yes, Your Honor. As far as service of process goes, when it comes to a garnishment, plaintiff is not required to serve the writ of garnishment upon the defendant. Rather, they are required to serve the writ of garnishment upon the garnishee, who then serves the writ of garnishment upon defendant. As far as the other objection, not being able to afford it, unfortunately, is not one of the valid objections found in 3.101 K2. So we would ask that the objection be denied today.
All right, ma'am, is there anything else you want to tell the court?
No, I can't afford that payment.
The court's prepared to rule in this matter. Two things. After a judgment was secured against you, one of the methods that the plaintiff who has a judgment against you can use is garnishment. But the way the garnishment process works is not the way you think it works. They do not serve you. They go to an employer, a bank, a credit union, someone that they think owes money that belongs to you. That individual or organization is called the garnishee defendant. The plaintiff serves a writ of garnishment on the garnishee defendant. It is the obligation of the garnishee defendant to do two things. They file a disclosure that says, yes, I do have something that belongs to Ms. Berry, or no, I do not. And then it is the obligation of the garnishee defendant to notify you that the writ of garnishment has been served against you. Your other objection, financial hardship, is something that is a reality, but does not rise to the level of a valid legal objection to garnishment. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Have a good day, sir.
You as well.
Mr. Rosen, I don't have Mr. Lee as of yet. Just want to let you know I hadn't forgotten about you.
Hi, Judge.
I don't have Mr. Lee as of yet. Want to let you know I hadn't forgotten about you. I'll get back to you at 10:30 if you had by that time.
All right, thank you, Judge.
All right. Let you go back to your other stuff.
All right.
We are on the record calling file number 1411478. The file is entitled Credit Acceptance Corporation versus Andre Lee. This matter is scheduled for hearing at 10 o'clock today on defendant's objection to garnishment. It's now after 10:30. Defendant has failed to appear. Sir, could I have your appearance?
Judge, may I please court? My name is Attorney Richard Bruson, my bar number 35222. I'm the attorney of record for the plaintiff. I'm also the respondent to defendant's objection to a garnishment. And he is not here to prosecute his objection, but the record should note that he is factually legally incorrect because, again, it may be more than 6 years from the date of the last payment on his car note, but the judgment was entered in this matter in January of 2015 under the legal doctrine of merger. The rights and the liabilities of the underlying contract forming the basis of the complaint gets merged into the civil judgment. The judgment will not expire until 2025. Therefore, I, based on non-appearance and also on the legal matter submitted for review, I ask that you deny the objection.
Yeah, the defendant has failed to appear. No good cause for that failure has been shown. Despite his claim in his writ that the last payment was made in 2014 and the statute of limitations has been reached in the state of Michigan 6 years, he's confusing the statute of limitations for the institution of a contract claim with the life of the judgment. Judgment lives for 10 years. This judgment was rendered in 2015. Defendant having failed to appear and having failed to state a valid objection to garnishment, the objection to garnishment will be denied. Thank you, sir, for coming in, and let's be safe.
Thank you.
You're off the record.